In this video, I'll discuss sentence hearings in the District or Supreme Court of Queensland. If you enter a plea of guilty and are sentenced in the District or Supreme Court of Queensland, a judge will preside over your sentence hearing. It is the judge who will determine the penalty you get. You'll first of all sit in the dock. Before your sentence hearing, you'll need to sit in the dock, which is generally positioned in the back of the courtroom. The dock is where defendants must sit in the District and Supreme Courts during their sentence hearings. There will be corrective services officers present beside you in the dock. The prosecutor and defence will each announce their appearances. At the start of your sentence hearing, the prosecutor and your barrister will announce their appearances to the court. This means the prosecutor and your barrister will they'll each say their names, they'll tell the judge who they represent. It is common practice for a barrister to represent defendants in the District and Supreme Courts in Queensland. Your barrister will do most of the talking for you in court, and your solicitor will be present with them. After your barrister and the prosecutor have each announced their appearances, the prosecutor will ask for you to be arraigned on the indictment. That is, if this hasn't happened before your sentence hearing day. They'll also ask for you to be arraigned on any summary charges transmitted to the court from the Magistrates court. Now, the court needs you to formally enter your plea of guilty to each count on the indictment. And this process is called the arraignment. And I'll just explain to you what the process is so you understand. You'll need to stand in the dock. The judge's associate will then read out the first count, that is the offence on the indictment. The associate will ask you how you plead, that is guilty or not guilty. The associate will do this for each count on the indictment one by one. And the process is like this. The judge's associate will say to you, you stand charged on whatever date it is, at whatever place, and they'll say the text of the charge on the indictment. And they'll ask you, how do you plead, guilty or not guilty? The usual response is guilty, Your Honour, or guilty. The judge's associate will then say to you, you have been convicted on your own plea of guilty. Is there anything you wish to say as to why sentence should not be passed? At this point, the judge will usually tell you just to sit in the dock. You don't need to say anything at that point because you have a barrister representing you. Now, the next step after the arraignment is for the prosecutor to make submissions to the judge. After you've entered your plea of guilty to each count on the indictment, the prosecutor will stand and make submissions to the judge. When the prosecutor makes submissions, they'll tell the judge such things as the facts for the charge, what you did. The prosecutor may hand the judge a document referred to as either a sentencing schedule or a schedule of facts. And this document will contain all the information for each charge on the indictment. It'll include any details of harm you caused to a victim, any details of any loss you caused to any persons. They'll also tell the judge the penalty they say you should get. They'll tell the judge any aggravating features of your case. Now, aggravating features are things about you, the victim, or the offence that may mean you should get a higher penalty. After the prosecutor's made their submissions to the judge, your barrister will stand up and make submissions on your behalf. When your barrister makes submissions for you, they'll be doing two things. Firstly, they're telling the judge about you as a person. Secondly, they're trying to persuade the judge to give you a particular penalty. The reason your barrister tells the judge about you as a person is because the law says the judge must have regard to your character, your age, and your intellectual capacity when they sentence you. Your barrister is in the best position to tell the judge about these things on your behalf. Things your barrister may tell the judge may include what grade you got to in school, if you've completed any formal qualifications or trades, if you've had any traumatic events in your life, your work history, if you've been employed, your personal circumstances. For example, if you're single, have a wife, husband, children that you care for, what your plans are for your future once you put this offence behind you. Any issues you may have had in your life that may have led to your offending. Any positive things you've done in the community. If you have character references or a medical report, such as a psychiatrist report, these will be given to the judge for the judge to consider when they sentence you. Your barrister will discuss penalty. They'll tell the judge what penalty they believe you should get. Your barrister may give the judge cases, and these are previous court decisions to support the penalty they advocate you should receive. If the prosecutor has given the judge cases, your barrister may comment about them. If the penalties in the cases appear to be too high, your barrister may tell the judge why your case is different to them. Your barrister will do this to convince the judge you should get a different penalty to the persons mentioned in the cases relied upon by the prosecution. Your barrister will tell the judge about any mitigating features in your favour to help persuade the judge to reduce your penalty. Mitigating features are things personal to you or the facts of the case. Now, examples of mitigating features include the following. You entered a plea of guilty at an early stage. You've shown prospects of rehabilitation. You've demonstrated remorse. You've repaid the victim for any loss you caused to them as a consequence of committing the offence. Your offending was out of need rather than greed. Your offending was spontaneous rather than something that you planned to do. You cooperated with the police in their investigation of the offence. You made admissions to the offence to police. You have good character and have never committed a criminal offence. And you were young at the time you committed the offence. They'll mention any of those things applicable in your case. Not all of them are applicable, but they're just examples. Once the prosecution and defence have finished making their submissions, the judge will pass sentence on you. You must stand and listen to the judge. When the judge speaks, they'll say what they've taken into consideration when deciding on the penalty they ultimately give you. Such things the judge may mention can include the facts for the offence, what you did, the mitigating features of your case, things in your favour, aggravating features of your case, that is, the negative things about you or the case in itself. After discussing these things, the judge will tell you what penalty they give you.